So in this video, we're going to talk about what do you do when you have an idea that you want to protect and about provisional applications for patent. So many times clients come to us and they're like, they have an idea that they want to protect. And either they're in the very early stages, they're still working out how it's going to fully function or how to take it from being an idea to an actual product. And they might need to do research and development or manufacturing, and they're just not sure what they should do next. And a provisional application for patent is a good place to start, but there's a few things to know. So first of all, we need to be clear that an idea itself is not patentable. You need to know how something is going to work. So there's a difference between an idea and an invention. Inventions are protectable by patents. Ideas have no protection. To give you an example, the idea of a flying car is just an idea. But knowing how it's going to fly, all the different mechanisms, all the different ways it's going to have to, the thrust to lift it off the ground, to make it go forward, reverse, all of those separate mechanisms will probably involve multiple patentable inventions to make a car fly. So that's just, an idea. Same thing would happen, So it's important to understand the difference between an idea and an invention, because many people think they can protect an idea. And an idea is a lot more specific. An invention is a lot more specific than what an idea is. So this is a chart from my book that just talks about, when you first come up with an idea over here, and then deciding whether or not it's even worth going through the patent process, because it is a very costly process, and unless you have to look at it as an investment. If it doesn't make sense to invest in it, then there's probably no reason to do it, unless you really just want to have your name on a patent, which sometimes we do get clients that want that. There are people that are in research that it's not really about converting the patent into an asset for money, but more of a CV builder, or more of just they want to be an inventor with patents. So, when you have an idea, how something can be done. Example, a flying car. How can we do this? You start whiteboarding everything, you brainstorm all the ideas, and then you start preparing an initial business due diligence. Okay, how are we going to make money off of this? Do I want to move forward with it or not? Do I want to sell this? Or do I want to license the invention so other companies can use it? Maybe you want to do both, sell the product and also license it. Maybe you want to be a standard. If you think of something like Bluetooth, that's a standard that's out there, and companies pay some Bluetooth association for their royalties to be able to use that patented technology. You also might just want to sell the patent itself. So knowing these at the beginning could take you down different paths. Knowing who your competitors are, what are they doing, and having an idea of what your time is. And really doing some research about the business to make a decision. All right, does this even seem like there's something from a business perspective that's there that makes sense to invest in or move forward? If the answer is no, then of course, go back, brainstorm, come up with a new idea. If the answer is yes, then, there's two ways. We generally suggest to start with a search to do your legal due diligence, figuring out what, if anything, is patentable in this invention and how strong that patent would be, meaning what sort of gap would you have that competitors would need to get around in order to compete with you? Or did you create a large enough gap that there's no way they can get around it, that you really have a nice commercial choke point over the industry so that competitors can't just easily design around your patent? So that's usually done with a search. But a lot of times clients come to us and they're still very early on and they want to file what's called a provisional application for patent. Sometimes this is done after the search. We do that a lot because it does help us to know what we feel is actually patentable here in drafting the provisional application or drafting a non-provisional, and a non-provisional is the one that actually gets reviewed and can turn into a registered patent when we're talking about utility. For design patents, which are just cover the look of a product, there is no provisional application there. There it's just straight to filing. So let's take a look at some of the requirements. So I recently was speaking with a potential client who said, hey, all I need to do is just file out that provisional application for patent cover sheet, and that's what a provisional is. And the answer is no. This is just one part of it that you have to file. So the USPTO here has what you need, and I'll put this link in the video below, but I kind of put it together into something much simpler to look at. So the main thing that you have to have in a patent, a provisional application, is the actual description of the invention, what it is that you're doing, what it is you're claiming. It's supposed to be end drawing, so. Without that description, the provisional application is nothing. So that's why you can't just file this cover sheet. You have to file the cover sheet. That's one of the requirements for the USPTO to get a filing date. But the whole application is not just the cover sheet. That will not give you any protection. You need to disclose. That's the deal you make with the government is for a patent is you'll get a monopoly, but you have to disclose it. Now that monopoly only comes much later on, and I have another video that discusses some of the pitfalls that I see with inventors thinking about provisional applications. But this one is just more about what needs to go into the filing. So it must include a description of the invention, meaning it should be written like a guidebook or a manual. And what we say is another person with the same skill in the same field would be able to pick that up, read it, and understand what the invention is. That's what required. That's what enablement is. That's number 2 here is the description of the invention must be sufficient to enable a person of ordinary skill in the relevant field to make and use the invention. So you do have to teach how to make it. You can't keep part of it secret, because if you don't enable it, then your patent's going to be worthless, or the provisional might be worthless. And it's all about the description. So use as many figures, flowcharts, drawings, whatever you can to describe it. It is possible to put a picture, photos into a provisional, but the more you disclose towards the invention, the better it might be later on, because you might need to pull that out when you're writing the non-provisional. And what I mean by pull that out is you might need that subject matter, because you only get what's in the provisional application. If there's something that's not in the provisional application and you disclosed it to someone while it was pending, it's not protected, or it doesn't have the possibility for protection. And again, that part is discussed a little bit in my other video about the pitfalls of provisionals. Of course, the government's going to want their filing fee, the U.S. requirement for the cover sheet, and then also to just know that the non-provisional application must be followed by the provisional must be followed by a non-provisional that's filed within 12 months. Otherwise, it just expires and does nothing for you. And if you disclose it to people during that 12 months, you lose any potential protection that the provisional might have had. So, the requirements, this is just, the provisional application must also include the filing fee and a cover sheet to identify, the application, the inventors, their residence, title of the invention, correspondence address, and if any government agency has any interest in this, if you receive funds from the government, you need to let them know that. And that's all in here. So, key takeaway is ideas are not protectable, inventions are. Provisional applications for patents you have to be very careful with, because A lot of people think that they're just something simple, but they're not. They still need to be drafted to the level of a non-provisional. It's all about the enablement, all about the disclosure, especially if your software, every which way you can think of doing this, as many flowcharts as possible you really want to put in there. Any questions, always feel free to reach out to us. If you like this video, please subscribe below. And thanks for watching. And I'm sure we'll have some more on the same topic. Take care.